Fundamental powers of the state. The inherent powers of the state are 1. Police power, 2. Power of eminent domain, and 3. Power of taxation. What are the similarities of these inherent powers? 1. It is inherent in the state, exercised even without need of express constitutional grant. 2. Necessary and indispensable, as the state cannot be effective without them. 3. Methods by which state interferes with private property. 4. Presupposes equivalent compensation, and 5. Exercised primarily by the legislature. What are the distinctions in the inherent powers of the state? A. Police power regulates both liberty and property, while eminent domain and taxation affects only property rights. B. Police power and taxation are exercised only by government. Eminent domain may be exercised by private entities. 3. Or C. Property taken in police power is usually noxious or intended for a noxious purpose and may thus be destroyed, while in eminent domain and taxation the property is wholesome and devoted to public use or purpose. D. Compensation in police power is the intangible, altruistic feeling that the individual has contributed to the public good. In eminent domain, it is the full and fair equivalent of property taken, while in taxation, it is the protection given and or public improvements instituted by the government for that taxes paid. What are the limitations of the fundamental powers of the state? Generally, the Bill of Rights, although in some cases the exercise of power prevails over specific constitutional guarantees. The courts may annul the improvident exercise of police power, from the case of Quezon City versus Ericta and Philippine Press Institute versus Comelec. Police power. Definition: the power of promoting public welfare by restraining and regulating the use of liberty and property. What is the scope and characteristics of police power? Police power is the most pervasive, the least limitable, and the most demanding of the three powers. The justification is found in the Latin maxims Salus populi est suprema lex and Sic oteri auto aut alienum non lidas, or use your property in such a fashion so as not to disturb others. Police power cannot be bargained away through the medium of a treaty or a contract, from the case of Stone versus Mississippi and Ichong versus Hernandez. Taxing power may be used as an implement of the police power, from the case of Lutz versus Araneta and Tio versus Videogram Regulatory Board. Eminent domain may be used as an implement to attain police power, from the case of Association of Small Landowners versus Secretary of Agrarian Reform. A law enacted in the exercise of police power to regulate or govern certain activities or transactions could be given retroactive effect and may reasonably impair vested rights or contracts. Police power legislation is applicable only to future contracts, but equally to those already in existence. Non-impairment of contracts or vested rights clause will have to yield to the superior and legitimate exercise of the state of the police power. From the case of Ortigas and Corporation versus Court of Appeals, 2000. Thus, despite the retroactive effect of PD 957 or the Subdivision and Condominium Buyers Protective Decree, there is no violation of non-impairment clause because the decree is a valid exercise of police power, and police power prevails over contracts, from the case of PNB versus Office of the President. It is true that the court has upheld the constitutional right of every citizen to select a profession or course of study subject to fair, reasonable, and equitable admission and academic requirements, but like all rights and freedoms guaranteed by the Charter, their exercise may be so regulated pursuant to the police power of the state to safeguard health, morals, peace, education, order, safety, and the general welfare of the people. This regulation assumes particular pertinence in the field of medicine, to protect the public from potentially deadly effects of incompetence and ignorance. from the case of Professional Regulation Commission versus De Guzman 2004. The right to bear arms is a mere statutory privilege. The license to carry a firearm is neither a property or a property right, neither does it create a vested right. A permit to carry a firearm outside one's residence may be revoked at any time. Even if it were a property right, it cannot be considered as absolute, as to be beyond the reach of police power. From the case of Chavez versus Romulo. Like timber permits, mining exploration permits do not vest in the grantee any permanent or irrevocable right within the purview of the non-impairment and due process clauses, since the state, under its all-encompassing police power, may alter, modify, or amend the same in accordance with the demands of the general public. In the case of Southeast Mindanao Gold Mining Corporation versus Balete Portal Mining 2002. As a license to operate a motor vehicle is not a property right but a privilege granted by the state, which may be suspended or revoked by the state in the exercise of its police power. In the interest of public safety and welfare, subject to the procedural due process requirements. From the case of Metropolitan Manila Development Authority versus Garin 2005. RA 9257, otherwise known as the Expanded Senior Citizens Act of 2003, is a legitimate exercise of police power. Administrative Order Number 177 issued by the Department of Health, providing the 20% discount privilege of senior citizens shall not be limited to the purchase of unbranded generic medicines, shall extend to both prescription and non-prescription medicine, whether branded or generic, is valid. When conditions so demand, as determined by the legislature, the property rights must bow to the primacy of police power because property rights, although sheltered by due process clause, must yield to the general welfare. From the case of Carlos Superdrug Corporation versus DSWD. Who may exercise police power?